welcome to this webinar, which is the first international construction webinar from Hawkswell Kilvington this year. There will be some more coming up, but we'll focus on today's subject first. A little bit of housekeeping. The plan is to do about 45 minutes speaking with some time at the end in order for some questions. And if you do have any questions, can I ask you to use the Q&A function and not the chat function, just so we can keep track of everything. So this is a webinar on procurement of tunnelling and underground work. I've come up with the bold title of the modern procurement, and it will also cover issues in relation to the FIDIC and the Emerald Book. Now, if you were expecting a talk on ground conditions clauses and only grounds condition clauses, I'm sorry. We'll do that to some extent, but there's a lot more that I'm planning to cover. Now, back in 2023, I presented a paper to the Society of Construction Law in the UK on contracting practices for tunnelling and underground works, which was followed by a paper last year. And what struck me when I was preparing that paper on contracting practices, which was very much focused on the construction contracts that are used for tunnelling and underground works, was that the success of a project depends a lot, not only on the form of contract and the provisions that are used there, but also the procurement decisions that were made before that. And these projects, tunnelling projects, are, in my experience, more than many other types, very much dependent on the behaviours of the parties. Now, the contract itself can influence the behaviours of the parties, but getting the contract right and procurement decisions up there, along the way have a great influence. Now, I also thought it'd be helpful to explain what this webinar is about and what it's not about. As I said, it's on the wider topic of procurement, although we will be going into issues of contracting strategies. And in terms of procurement, what I mean there is the actions and decisions from project inception to the contract. We're not going to be getting into issues of management and performance of the contract itself. Now, these actions and decisions beyond, but including contract statutory, not only determine the allocation of the risk in a contractual sense, but also the behaviours and the likely success. This webinar is also not about mega projects. Whilst many tunnelling and underground projects are mega projects, they themselves, these mega projects, have their own characteristics, particularly involving issues in terms of politics, both with a capital P and a little p, that contribute a greater influence as to the success of them. Now, there are a number of different types of tunnelling projects, and I will come into those in a moment. And I've realised that when I was preparing this, that this was an ambitious topic, because there is an awful lot to cover. But what I've tried to do is to come up with some common features. So in terms of context, we've had the introduction. I'm going to talk very briefly about different types of tunnelling and underground works and what I mean. Defining project success, because as I said, that's the purpose of the procurement process. To consider why tunnelling and underground work is different from other forms of projects and civil engineering exercises, to look at the procurement process and then look at some of the features that are involved and the considerations that need to be made as part of the procurement process. Now, we think about tunnelling and underground works projects. Well, what do I mean by that? Well, most, if not all, civil engineering projects involve an element of subsurface work. For example, for the construction of foundations or a base layer. But what I'm really referring to are projects involving major elements of subsurface work, and where the ground is being used, and I will mention this several times, as the working material, as the construction material. Another way of thinking about it is, well, would you characterize a particular project by the subsurface element of that work? Now, from this relatively narrow and simplistic starting point, we immediately broaden out. And I could spend probably the next 20 minutes talking about all the different types of projects that fall within this category. And on the slide behind me, you will see I've mentioned a number. Some of these just involve, very simply, tunnels. Others will involve combined elements of subsurface work and above ground work. A good example are things like metros. And further still, there are some that involve the subsurface work and then the supply and installation of equipment, an MEP, for example, hydropower projects. So there's a wide range of these things, and the procurement route for all of those varies significantly. Another factor we have to do in terms of differentiating these is that you have to consider the location of the projects. Urban projects where a lot of tunneling and underground works is carried out have very different characteristics from the projects that are done in green fields or out in the hills, for example, in Scotland. Now, when we think about defining the success of a project, this is on the slide above me, we've got the very standard, commonly accepted Venn diagram that really is what we're looking for is an intersection between program, which is the time it takes to deliver, the cost of delivering, and also quality. Now, when I was preparing the contracting practices paper, I came up with a slightly different, refined version of this, and I've added two more. One is function, and the other is safety. And this very much illustrates one of the features of tunneling projects and why procurement decisions become so important. When I talk about function, what I mean is, does it stand up? Quite simply, because as we'll hear later, many of the procurement practices that are being adopted nowadays is driven by the insurance industry back in the late 90s and early 2000s, when there were issues about risk management and losses that were being incurred under CAR policies. And safety is also equally, if not more important, because a lot of the underground subsurface work is done in, I won't necessarily say dangerous environments, but more dangerous environments than many of the above ground projects. Then when we think about success, it's also important to think about recognize that the different players in the or different participants in the projects have different ideas of what success means. Now, from an employer, it's about obtaining the asset, getting what it is to be built within their budget at the time it requires. And I've added maintaining reputation, because as we've seen in tunneling projects, and there has been a history of tunneling projects getting a bad reputation, which is being reflected on employers due to the issues that are involved. And you only need to think about the headlines over the last 20 years. When we think about the Boston Big Dig, we can think about HS2, you think about Snowy 2, all of these things become very important for the reputation of the employer. Now, from a contractor's perspective, it's about performing the works at a profit, because they're not charities, and also maintaining their reputation. Now, the funder or the sources of funder is slightly different. Now, obviously, when we're talking about tunneling projects, many of them are public, but when they are certainly private projects or privately funded projects, they're looking about returnable returns on their investment. And insurers, which play an important part, are looking for the projects to be completed with the claim activity within an expected range. Now, all of these factors feed in to what I would suggest is procurement decisions. And then we think about the role of the construction contract. The construction contract, and we'll come to this a bit later, this is the sharp end. This is where all the procurement decisions will ultimately result in, and then there will be delivery and performance of that contract. Now, the purpose there very much is defining the project, but we're also now seeing that it is being used as a risk management tools. The objective is to create this productive relationship with clear mechanisms, so there are minimal disputes. I won't necessarily say claims, because claims are not necessarily bad if the contractor are allowing for them, and indeed in relation to unforeseen ground conditions, these are very much a feature of these projects. But the outcome is looking at the outcome of the role of the construction contract is it will influence and arguably establish, depending on caps on liability and the way in which it's drafted, the financial outcome. It will influence the behaviours of the parties, and it'll also influence the decisions as to the manageable risks. Now, when we think about risks in construction generally, again, on this slide behind me, I've set out a number of different risks that are commonly present in construction projects. And I've sought to allocate them, some to the contractor, which are very much where the contractor has full control over them, some which are very much in the remit of the employer, some which sit somewhere between, it could be one or the other. And then the last category is where there are external third parties. Now, from the contractor's perspective, we're thinking about pricing, we're thinking about doing the work, often the design of the temporary works, providing the equipment, providing the labour. The employer pays for it, for the project. It will be responsible for providing the site, and also, and most importantly, for specifying what it wants to be built. At the other extreme, when we talk about third parties, we've got the issues of ground conditions, interfaces, changes of law, political risk, a number of factors which obviously neither the contractor or the employer can do anything about immediately, although they will look to manage those risks. And as I say, in the middle category where we've got these risks that could fall between the contractor and the employer, these are risks that both the contractor and the employer have an opportunity to directly influence. Now, why is tunnelling and underground work different, or indeed is it? Now, the most obvious feature of tunnelling and underground projects is the ground, and with it, the ground conditions. Now, from a construction perspective, unlike above ground construction, a major part of the construction material is the ground itself. It's not just load bearing like foundations, but it also is the working material. There is an inherent lack of homogeneity. I knew when I put that word in, I would struggle on it, which makes it a complex material to work with. And the property of the ground influences the design itself and also the means and methods of working. And there are temporary work design becomes very important, because sometimes it can become the greatest element of the work itself. The excavation is in itself temporary works, and it requires decisions to be made in real time, sometimes daily, sometimes even hourly. And when we're using techniques such as sprayed concrete linings, obviously that involves real-time monitoring and very careful decisions to be made. Another factor is that permanent works are covered up almost immediately, which in itself gives rise to issues as to quality assurance and issues as to determining whether or not the contractor has performed. Now, there are a number of other features that also come in. Now, one of them is the fact that tunnelling uses specialist equipment. The obvious example is tunnel boring machines, but there are also cutters, mining equipment. I could go on. And these themselves have long lead-in items, have long lead times, high capital costs, and there is sometimes a scarcity of them. The equipment choice strongly influences methodology, program, and risk, and equally methodology will influence the equipment choice. Now, it has specialist workforce requirements. It demands crews that are trained in confined space safety, logistics, segmental lining, again, the techniques that are being used, and workforce availability can be a hard constraint. There are constraints on logistics. In order to access the working site, which is underground, there has to be access points via shafts and portals. This can provide constraints in relation to material handling and spore removal, storage, and emergency planning. And these constraints themselves can directly affect productivity and program resilience. Complex enabling works are often required, utilities removals, access, and the likes. There's a higher proportion and complexity of temporary works, as I've mentioned. There's often a lot of interfaces with third parties and multiple stakeholders, particularly when we've got tunnels or construction in an urban environment. There are health and safety challenges from confined spaces. There's a lot of permitting, consenting, and approvals required. There's also this question about availability of project insurance, which I'll touch on a little bit later. You'll also hear that tunneling projects being described as linear. Now, when I think about this, on paper, yes, that may be true because tunnels start from one end and they'll go to another. But I think that is probably an oversimplification. But actually, it's more appropriate to be thinking about it in a way that the progress of a tunneling project can be disproportionately impacted in terms of the critical path by unexpected conditions encountered during construction. And when progress stops, it really stops. There's no just slowing down. It's a complete stop. Now that, of course, comes with some significant and direct cost implications. So when we're looking back at the risks in construction, I've highlighted here some of the issues that are particularly relevant in relation to tunneling projects, or particularly more relevant to tunneling projects. Now, when we think about tunneling and insurance, now back in the late 1990s and early 2000s, and I said we got to I won't necessarily say a crisis, but a critical point. And this was where it was commonly known, I think, well, certainly now, that insurers were questioning whether it was sustainable to continue to insure tunneling projects. And the issue was that there was a lot of losses. There were, and I'm not going to talking about necessarily about the extreme situations of tunnel collapses, but there was a lot of losses, issues in relation to water ingress, minor collapses, losses within the tunnel, which led to the preparation of codes of practice on risk management for the purpose of the insurance industry. Initially, this was produced by jointly by the British Tunnelling Society in the UK with the insurers. And then subsequently, an international version was produced, and we're now on the 3rd edition. And the objective here is to promote and secure best practice for the minimisation and management of risks associated with design and construction and tunnel works. And what the Code of Practice does is it produces a framework from project development to construction about identifying and assessing risk throughout these processes. And preparing risk registers and risk management plans. And in the design phase, it's very much looking at constructability. And then in the construction stage, it's looking at method statements and the ways in which we can mitigate it. And the reason why we've produced this is so that there is a better behavior, shall we say, and there is a shift in the approach of the industry to focus more on risk management and also the management of risk in the implementation, in the procurement and implementation of these projects, in order to ensure that they continue to be insurable. Now, you might be understanding why might be thinking why I keep going on about insurance, but obviously because of the risks involved and the potential losses that may be incurred to both to the works and to third parties in tunneling projects, insurability becomes a key issue. And the Code of Practice has created introduced a discipline in terms of risk management. Now, in terms of tunnel procurement itself and decision making, now it should be obvious that it involves a number of different key decisions. Now, for the simplest of projects, it's fair to say that the procurement may be relatively simple. Now, where the work is being procured on a single contract and the ground is known, that apart from having to deal with some specific subsurface conditions in the contract itself, the procurement process can be relatively straightforward. Now, but more generally, as we've been mentioning, these projects involve a lot of interfaces, third parties, variables, constraints, and uncertainty. Now, I'm not necessarily saying these projects are unique in themselves, but they are unique in the combination of the issues and in the magnitude in which these decisions can affect the ultimate success of the project. Now, the first one is the very obvious point about defining the project. It's about defining the function of what is being built, its location, the completion date, and the cost parameters. The next one is about identifying the risks. Now, this extends beyond simply sign conditions into planning consents required, and also the third-party interfaces and working out where those constraints are. Another decision that needs to be made is about the packaging strategy. Now, again, in the simplest contracts, you will have one contractor who will do all of the work. But more complex projects will often involve multiple different contractors or multiple different suppliers. For example, in metros, you'll have the tunneling contractors will be interfacing often with the station contractors. And so there'll be an interface at those ends. There will be MEP and fit out contractors. There will be, in a hydro project, you've got the civil works, and then you've got the plant and equipment works. Now, these interfaces, both at a design phase and a construction phase, can be critical, and they can cause these projects to stop. So it's very important early on to identify the packaging strategy. Then we have the contracting strategy, which includes both the enabling work strategy, pricing models, design responsibility, etc., which I'll come on to. There needs to be engagement with stakeholders and third parties to ensure that things like asset protection agreements are in place. The land also needs to be identified, and the access requirements needs to be identified. Now, on the right of this slide, I've got a helpfully generated, AI-generated simple chart, which is talking about decision effort versus project comfort. This is an absolute oversimplification of it, but really, what the whole purpose of this chart is to show is that it's been found through many studies that the influence of the decisions is much greater in terms of overall cost if made earlier. So you've got greater effort at the outset can reduce the risk of cost overruns at a later. And procurement very much is a balancing exercise about understanding certainty of the risks and then cost and time. And time is not just about time in the contract, but time in the overall project timeline. Now, one of these features, and very critical feature, is the design phases. Now, from here, there are many different phases. You will start with feasibility, go through to concept, the preliminary design, then we often produce reference designs, and then detailed designs. Now, depending on the contracting strategy will depend on which design and the level of design maturity that is needed before going to tender. Now, with a design build approach, we're normally at a preliminary or reference design being produced by the employer, at which the contractor will then pick up. In a design bid build or an employer design approach, the design will have to be more detailed in order to define the scope and to avoid issues of scope creep later. I've introduced this idea of base case to pick up a little bit later. But going from left to right over this chart, you have greater definition in time, greater definition of the design and greater certainty. But what is the role of design and why is it important? Now, here you go, is a bit of a spider chart. This is what my head looks like when I'm thinking about these things. Now, in the middle of this is the design. Now, that design includes over the various different stages that we've had in the previous slide. But what you can see from that is how the design and tunneling projects is influenced by and influences multiple different factors, and they are all interrelated. You've got issues of the ground investigations, which will inform the ground conditions and the knowledge of the ground conditions, and then the geotechnical baseline report if you use it. The ground conditions will influence the design and the design methodology, which will then go to construction methods and the labor requirements and equipment requirements and issues of buildability. The design will identify the alignment, which will then lead into issues of access arrangements and etc. and etc. It's complicated. And really what we're trying to do as part of this procurement process is to understand all of these interfaces to an appropriate degree in order to then procure it through a contract and move to the contract phase. Now, the other issue, in addition to design, that is as important, if not more important, is the question of ground conditions. Now, the ground conditions themselves, as I mentioned before, are fundamentally important because they are the working material, and it will influence, the ground conditions will influence the tunnel design and the method selection. There are an innumerate number and multiple different construction methodologies in tunneling, from using TBMs all the way down to basic mining. And the different grounds will point towards different methodologies. Now that in itself will then lead us into questions of cost, safety and program. Now, subsurface uncertainty, as you all know, is the leading cause of delays and claims. Now, as I mentioned earlier, claims are not necessarily a bad thing when you're allocating risk, but they are claims and need to be resolved. And then if not resolved, we'll go into disputes. And this all arises around unforeseen ground conditions. Now, if you do encounter an unforeseen ground conditions, it's not just a simple question that's going to take a bit more time or a bit more work. It can actually cause deviations from planned tunnel design and methods and require you to go back to the drawing board. So it's not only a question of delays in terms of the construction, but actually requires the parties and the contractor to go back and have a look at the design itself. Now, this itself leads to the necessity for robust ground investigations. Now, the more ground investigations you do, the more this will reduce the uncertainty. It will also enable the optimization of the design and enable there to be more realistic baselines and cost estimates that are being produced. Now, the question is always how much investigation needs to be done during the procurement phase. And this leads back to the previous question about the decisions that are being made. Now, there is no one answer to this, and it depends on ultimately procurement strategies and is, I would say, needs to be kept under review all the time. There are certain geographical locations where the ground conditions are relatively well known, for example, in London or in Hong Kong, but even in Crossrail, which was, for those who don't know, was a tunnelling project across London. Hundreds of millions, I believe, was spent on ground investigations in order to reduce the uncertainty. But ultimately, it becomes a question of balance, a balance of time, cost, and knowledge. Because the understanding of the ground conditions leads into the question about the allocation of ground condition risk. Now, this is achieved either through the design, the selection of the pricing mechanisms, or more commonly, but in addition to those two other methods, through adverse site conditions clauses or differing site conditions clauses, the classic clause 12. Now, the starting point, as everyone will probably know, and certainly under common law, under English law, is the ground conditions are the contractor's risk unless the contract provides otherwise. And as a result of that, we've seen development of different approaches, different mechanisms that are being used contractually. FIDIC and the ICE form use this idea of foreseeability, the ground conditions that were, whether or not the ground conditions were regionally foreseeable by an experienced contractor. NEC forms use a slightly different approach, which is what I would describe as a probabilistic or commercial approach. The US adopts this material difference test. Now, the issue with each of these tests is, well, what do you mean by reasonably foreseeable? What do you mean by such a small chance that someone would not have taken it into account, or a material difference? Now, this is where you have a lot of disputes. And so as a result of that, we've led into the best practice, at least, has adopted the use of geotechnical baseline reports. Now, these are contractual documents. They're not factual descriptions, and they define what ground conditions risks are assumed by a contractor. They're not necessarily the actual ground conditions, but it's assumed contractually. In effect, they define what is foreseeable. And it contains baseline statements with physical conditions, which is the ground conditions, but also the behavioural conditions, because you need to be able to assess whether or not only the ground conditions are not what you expect, but it's having an impact on the design methodologies in the construction. Now, GBRs have been endorsed for the tunneling industry since the 1970s. But with that said, there is a mixed experience in them, because it very much depends on the quality of the authors and the quality of the report. They need to align with other contract documents. And also, they need to be prepared on the basis of sufficient information, both the information, the amount of sufficiently a level of design maturity, but also questions as to methodology. This in itself gives rise to issues in relation to timings between design bid build and design build, because in order to identify proper behavioural conditions, as I said, you need to have the design developed to a certain stage. But established practice in, for example, design build, you will have the design will not be developed. It may only be a basic preliminary or concept design or a reference design at that stage, with the expectation that the contractor is going to be involved in the detailed design, which in itself will go forward into the construction methodology. The standard approach to this, or at least the recommended approach by Syria and Askey, who have produced some recent guidance on these, on the preparation and use of GBRs, is to use a two-stage approach in involving the contractor in the preparation of the GBR. Now, they are commonly used, as I say, but they're not commonly accepted or adopted in contracts, in standard form contracts. The FIDIC Emerald book, which is, I'll talk about in a little bit later, but is probably one of, if not the only, international standard form for tunnelling that is being produced, has adopted geotechnical baseline reports. And the way in which it does that is by amending the definition of unforeseeable to talk about anything that the physical conditions described in the GBR are considered to be foreseeable, and the subsurface physical conditions outside the scope are defined as unforeseeable. NEC contracts, which are commonly used, don't in themselves incorporate GBRs, but have been amended to use them. On the slide, I've included the cross-rail drafting that was used, and there's also been some recent guidance published by the International Tunnelling Association for the use of NEC for underground works, which also produces and is another form of wording that they suggest could be used for GBRs to be adopted in the NEC forms. Now, when we get to contracting strategy, now this is the sharp end of procurement. So all of the decisions that we've had previously are leading in ultimately into the signing of the contract. This is not just about practices, but the strategy in itself is led by many of these decisions and involve questions such as risk, the choice of contract form, risk allocation, design responsibility, pricing mechanism, and you'll see I produced on that slide a couple of examples of proper illustrations of what you will often see about questions about understanding of risk in terms of pricing and design allocation. But the key considerations when we're thinking about contracting strategy is also market practice and conditions, what the contractor is willing to accept, what the supply chain is willing to accept. So it's all very well coming up, well, I want to do this, the employer, the client coming up with an idea that it wants to produce this on the basis of a lump sum, But if the market is not willing to accept that, you're not going to get any bids. It needs to be aligned with the other procurement decisions. And it also will influence and can be influenced by procurement questions as to speed to site and speed to contract. Now, you'll commonly hear when we're talking about tunneling contracts, this idea of fairness or balanced contracts and the Abrahamson principles going back to 1973. In simple terms, this is about the allocation of risk to party that is in the best position to manage or mitigate that risk. It's a very simple term. And the question I have, and I've always struggled with this slightly as a lawyer, is, well, what does that actually mean when we're talking about fairness? Now, the objective of having a fair and balanced contract is to ensure that the employer is attracting competitive bids, but also, again, to influence the behaviours of the parties as to the way in which the contract is managed. And if you place too much risk on a contractor, then they may have a tendency to go into a more adversarial approach. So you're looking for somewhere in the balance. But what you will see here, when we're thinking about things like allocation of risk, time and cost, the contract is only one part of it. So the cost of the contract and the outcome of that contract needs to be considered in the overall scheme of the time it takes to prepare the procurement decision, prepare the to go through the procurement processes and take the decisions to arrive at a contract in itself, and also the costs that are involved. The quicker you go with the less preparation, there is a risk of greater uncertainty, and that's greater cost overrun. And there are numerous forms of contracts, and I don't really want to go into them in too much detail. The main point is it's very much market driven. The standard practices is very much in the UK, it's NEC, internationally, at least sort of from a non-jurisdictional point of view, it's FIDIC, but most jurisdictions will often use their own contract and amend them to a greater or lesser step to adapt to the greater involvement of subservice works. Now, I mentioned we talk about the FIDIC Emerald book. This is the conditions of contract for underground works. It was a joint endeavour by FIDIC and the International Tunnelling Association, published back in 2019. There's been a number of there's been one set of amendment that was produced in 2023, and this amends and picks up on some largely typographical points in the 2019 edition, but also picks up on some issues that were present in the 2017 issue of the FIDIC Yellow Book, the design build form that was the basis used for the Emerald Book. It's based on this fundamental principle of a balanced risk allocation that I mentioned. We're going back to the Abrahamson principles. And ostensibly, it's a design build form, as is the Yellow Book, although there is a curious addition which talks about except as otherwise specified in the employer's requirements. As I've mentioned, it adopted a geotechnical baseline report, and also, more interestingly, a hybrid pricing mechanism, which I will touch on in a moment, and a mechanism for adjusting the time for completion. There are other changes that have been introduced in order to tailor it specifically to the nature of the work, and also the issue of risk management, going back to the code of practice with the insurers, such as risk registers and risk management. Now, under the FIDIC Emerald Book, you've got excavation and lining works, and it's very much defined as a specific aspect of the works. And this is where most of the key provisions and the additions that you see in the Emerald Book versus the Yellow Book have been introduced. Now, there are two interesting features, and the reason why I'm talking about this is not so much to talk about the FIDIC Emerald Book, but to talk about issues in the context of procurement. Now, when we're thinking about the FIDIC, we're talking about excavation and lining works. It's relevant partly in terms of measurement and the way in which that work is management, but in two key features, one in terms of payment and one in terms of the time for completion. Now, in terms of payment, it has, for the excavation and lining work, some items can be identified as lump sum items, fixed rate items. Some are identified in time related items and some are put in as quantity related items. And these are identified in the bill of quantities. Now that's pretty standard and people won't necessarily think that there's any great surprise there, but you end up with this hybrid mechanism. Now, in terms of the time for completion, this is something which is new and I think quite novel. And at the outset, the contractor has to produce a completion schedule, which is a logic-linked schedule of activities with the milestones in order to achieve the time for completion, which then go into the program. And also, the contractor has to produce a schedule of baselines, which includes the item of works and activities and the production rates. And the FIDIC Emerald Book adopts a mechanism for assessing the time that is allowed in terms of the time to completion by applying the production rates in the baseline schedule to the actual measured quantities. And it causes it to be adjusted, either more to give the contractor more time or less. And as a result of this, in terms of both payment and time, it's the bill of quantities and the schedule of baselines that becomes very important. Now, if you think about this in a procurement perspective, the way in which the FIDIC Emerald Book is procured is on the basis of an employer reference design and also on the basis of the employer's proposed methods of construction. Now, this all goes together and feeds into a GBR, which is provided during the tender stage. So the employer is producing a reference design, the employer is producing the proposed methods of construction, and the employer is producing, or certainly heavily involved in producing, the GBR, and they're all quite dependent. Now, off the back of that, for the purposes of contracting, the contractor has got to produce its bill of quantities and its schedule of baseline, which then feeds into the completion schedule. And my observation on this is that can work if the level of design maturity is such that there are sensible decisions and there is a degree of certainty in relation to the overall design and also the proposed methods of construction. Now, if you are procuring this on the basis of a reference design which is only in a preliminary way and requires further work, and there is an expectation that the contractor is going to be involved in carrying out the work, this must raise questions as to whether or not it's going to be possible to identify all of the items of work for the purposes of the bill of quantities and all of the items that need to go into the schedule of baselines and appropriate production rates. And so I'm not saying that it shouldn't be used, but what it requires is a lot of informed thought as to how this is going to work and an assessment as the level of development and certainty that there is, both in terms of the reference design and the GBR, in order to come up with rates and quantities and production rates. Now, to conclude this, and I realize I'm coming to the end of my time, we're talking about modern procurement. Now, if you go back to what we've been talking about earlier, particularly about the understanding of the design and the ground, there is necessarily going to be a tension between the timings and the development of the design and the tendering, particularly in relation to either in design build contracts, but also in terms of the commercial aspects of these projects, because it is the contractors that are in the best position to assess working methods and costs and labor requirements and equipment availability, for example. And if you're going through a tender process, a procurement process, which is at arm's length from a contractor, then often, and this is where you end up with sort of what I would describe as some soft interfaces. This is where you can over-specify projects, or alternatively not necessarily take full advantage of the contractor's skills and capabilities and knowledge. And so what we've been seeing more recently is an increased use of early contractor involvement. Now, early contractor involvement is what it says. It's the involvement of a contractor at an early stage. And this is not new, and it is used on many different projects. And there are a number of different types of this. You can do it from what we various models. The first one is that I've mentioned is when we use something called a PCSA, a pre-construction services agreement, where the contractor is involved to carry out some initial perhaps design work or even enabling work in order to develop the scope, the specification, the program, and then ultimately then we'll lead into a second stage into the main works contract. You can have two-stage contracting where all of this is actually wrapped up, that process is wrapped up in one contract with an option to proceed, or it can actually be done post-contract award. So it's engaging with the contractor early on, following the award of the contract. The benefits of this is involving the contractors to develop the design, to assess buildability, to optimize issues, for example, like time and cost, to bring its supply chain to issues about carbon management, and also to coming up with appropriate strategies for health and safety. There is an option in the NEC forms, option X22, which is for use with certain types of contracts, particularly target cost and cost reimbursable. Now, this has been used successfully on a number of different projects, as I said, and I'm referring to these three: Crossrail, Thames Tideway, and the Bank Station Capacity Upgrade, which are all, I accept, UK projects. And this is largely because there's a lot in the public domain, I can talk about this. Now, Crossrail used something called optimized contractor involvement. In fact, Peter Rousel came up with this idea, and this was engaging with the contractors straight after contract award. There wasn't any contractual arrangement for it, but it was about assessing these issues and adapting and making sure in this initial period that there was a collaborative environment to optimize the situation. Thames Tideway used it and formalized it with an alliance agreement, where all the contractors were signed up to it, and they shared a benefit from the outcome of this. And again, it was post-contract award. In the Bank Station Capacity Upgrade, this was where there was something used called innovative contractor engagement, where TfL came up with a base case. And you remember back in the design context, this idea of a base case, came up with a base case, which was effectively going to be more expensive than their budget. And so they went out to the market and engaged with two contractors, and paid them to undertake this process, to go through to undertake essentially an optimization exercise. And this resulted in one of the contractors, Dragados, identifying a scheme that had a significant cost benefit. Now, having done that, those innovations then got rolled into a subsequent two-stage contract. And TfL entered into things called information agreements, which allowed the contractors who they're engaging to, allowed TfL to use the designs and the innovations that came up out of this exercise for the purposes of the later stage, even if they weren't subsequently instructed. Now, the big caveat of this is this is all about this involvement is very much has to be subject to procurement rules and procurement laws, and that's the difficult thing that requires a little bit of careful navigation. And the final point that I wanted to talk about was about carbon management. Now, tunneling is carbon intensive, and much of the carbon that is created or embodied is through the use of concrete steel, and also in the diesel that is used to power, for example, the TBMs and the site equipment. And there is a significant growing effort to manage and reduce carbon in the tunneling industry. There is also obviously a great, growing efforts in the wider industry as well. FIDIC has very recently produced a carbon management guide, and there's also PAS 2080, which is a public available specification, a public available standard, or an international standard guide for the management of whole life carbon and infrastructure. The ITA have published recently a paper on low carbon tunnel linings. So there's a lot of efforts going in. But the issue then comes in, well, how do you contractualize this? And this is something that the lawyers have been grappling with. And how do you embed this within your procurement process? Now, the starting question is baselining. So what are we going to measure against? What are the baselines? That very much depends on the data. It also depends on the measurement. So we've now got PAS 2080, ROCS have produced standards for the purposes of measurements. Lots of these organizations are now starting to get it. So we're getting more data so we can understand it. Then we get into contractualizing. I'm not sure if that is a word, but it's what I've used. Now, the question is, do you include these targets as binding or as aspirational? That's the difficult one, because again, it's a bit like, you could think of it a bit like the ground conditions. Parties are only going, the contractors are, the supply chain are only going to be willing to sign up to these binding targets if there is sufficient certainty as to whether or not they're achievable and whether they can be managed. Do we have enough information yet? Or should we do something in a way that is more aspirational? And do you do it in a, do you incentivize them? Do you use KPIs? Or do you actually penalize? And I use penalize in the loosest sense of the word, because I realize that in English law, perceptive penalties are not enforceable. Do you have it's the carrot and the stick? Do you liquidate the damages for failing to achieve targets? Now, this is still very much a developing field. But there's an interesting argument that's come up, an interesting example that has come up in the Lower Thames crossing, which used the competitive dialogue process, which isn't really a form of early contractual involvement, a formal form of early contractual involvement. It was very much during the procurement stage. But they entered into this competitive dialogue process with 3 preferred bidders in order to engage with them, to understand where the embodied carbon was, and to reduce it. And the results of that have been significant, have been very significant. And I think the latest prediction is that they're now down to about 1/3 of what was initially estimated. And again, that's an early engagement with contractors and with the industry to understand where these things can be achieved. Now, to conclude, and I'm slightly over my 45 minutes, and I apologise, but to conclude, now, tunnelling projects themselves are susceptible to cost overruns and delays due to their nature. I could have spent the last 45 minutes talking about all of the different headlines and getting into detail. But many of the reasons why you have cost overruns and issues that come up is through decisions that were made at the procurement stage. And that's not only about the choice of contract and the contracting strategy. Now, some of these are very macro issues. These are issues in relation to interfaces, land, and in many of the examples that I've mentioned today, a lot of it's about public reception and political issues, which is, I would say, to some extent inescapable, but needs to be factored in, and needs to be factored into the way in which we communicate the success of these projects. Now, in procurement, the adequate ground investigation is essential, and as importantly, all the other risks need to be understood, and time and cost needs to be involved in that. It's challenging, but not impossible. This is where I come up with the maxim: plan slow, build fast. It's about being flexible. There isn't a one size fits all. It's about thinking about your specific project and being informed as to the decisions that need to be made, and being engaged with the market in order to maximize and optimize. Now, on the right of the screen, I've got 6 pillars of effective procurement. After I'd prepared this webinar, I found these pillars, which were prepared by the Infrastructure and Project Authority in the UK in their project route map on procurement. Now, these very much capture what I was saying and go back to the procurement decisions that I've mentioned. It's about understanding the outcome. That's the specification. It's about engaging with the market. That's the competitive side and the risks that they're willing to accept. It's about packaging the works and the interfaces. It's about the contracting strategy, and about defining the successful tendering process and the route to market. The last one is about managing performance, and it's about managing performance of the contract itself, which is a topic for another day. So I've now come to the end of that. I hope that was interesting. I find this a fascinating subject. It's taken me a long time to prepare this, and I've got an awful lot more that I could have said. But what I try to do is to narrow down some of the key issues and to identify the themes. And so you can see that there's a degree of an arc that comes through, starting with the decision to procure a project, the wider issues, the key involvement, and the key importance of understanding ground conditions and undertaking adequate ground investigations, and also the important role that design plays in the procurement of these projects. So we do have a few moments now still, and I'm happy to go over if people have any questions to let me know if they've got any questions. I will say that I will be publishing and circulating these slides shortly after this, once I've picked up the typo on the last slide. I will also be producing a very short 3-page note on these points as well. I will also say, if you don't want any questions or don't want to raise them now, I will be available, and you can feel free to email me or call me, and I'm very willing to chat. This is a topic that is very close to my heart. Before I was a lawyer, I was an engineer, and I was also I'm also the son of an tunneling engineer, and my name is actually Benjamin Thomas Mellors, but the original thought was to call me Thomas Benjamin Mellors, which my father and his friends found hilarious, because for those in the engineering industry, you'll appreciate that it represents a temporary benchmark or a tunnel boring machine. So that's why I'm Ben and not Tom.